Okay, hello again, everybody. Paul Rabelais here. Got a lot to go over. Going to give you a little bit of background first, then we'll jump right into the subject matter. Do a little adjustment here. Sitting here in my home, Baton Rouge, Louisiana. I'm an estate planning lawyer. Crazy world. The focus of this video is not the crazy world. Focus on this video is, well, the title of it is, should you arrange your estate to avoid probate? And what does that really mean? So I got a lot of information to cover. It's going to be awesome. Couple of housekeeping notes. If you have a joke that's better than my joke of the day, bring it on in the live chat. If you have a question about this subject matter, or quite frankly, any kind of estate planning related subject matter, throw it in the live chat. This is YouTube live presentation number 4 of 20 daily YouTube live presentations. They're all different. And on the first 3, I know some of you have been on the presentations. There hasn't been a question that was asked that I didn't answer. Every time we get a few questions, I really like the Q&A part of it. So if you got a question, throw it out there. Sometimes it's hard for me to answer the question because I don't really understand it in the context of your situation. But nonetheless, I'm going to try to answer it anyway. So got a lot going on there. Got to put the old, Wyoming's back. Thank you, Lawrence. You're welcome. All right, all good stuff. Lawrence and Ron, happy to have you. Jump right in. Couple of the stuff I ask you to do every time you watch one of my videos. If you could hit the thumbs up, turn that gray to blue, that helps me out. If you want to subscribe to the channel, that helps me out. It just tells YouTube, hey, show Paul's videos to more people. That's all I ask. Okay, so let's jump right into the whole kind of probate discussion. And we'll probably go, I usually go about 50 minutes. Depends on questions, depends on how fired up I get. Let's go. All right, so when we talk about probate, let me give you a little bit of history and definition. So the term avoid probate, the term probate gets thrown around a lot out there. But strictly speaking, probate is really just having a judge validate that the will is valid. So you may hear, yeah, we're going through probate, or you may hear a little more formally, yeah, the judge has to, or we have to probate the will, or the judge probated the will. So strictly speaking, probate is really the judge signing some court order that the will is a valid will. When somebody dies, their will gets presented to a judge. Every state has formalities that must be met. So maybe if it's a will done in a certain format that requires a notary and 2 witnesses, and there's only a notary and there's no witnesses, well, a judge won't probate or validate that will, and you'll have to go back to the previous will, or maybe apply the law that occurs when no will exists, depending upon the circumstances. So that's just a formality. You may hear the word probate used in different contexts. I'd say in general, the word probate is used to describe the entire settling of a person's estate. And good morning, Roxanne from Alabama, to you as well. So we got some good morning people. Marilyn is here. Awesome. You're welcome, Tippy. I got a friend we call Tippy. And so good morning to all of you. Nice to see that. And I'm going on and off with the glasses because I'm getting old, probably not as old as some of you out there, but I can't see the live chat without my glasses on. But I think I look better with my glasses off. Stupid me, it really doesn't matter. None of that matters. Okay, so little bit more probate history, then we jump right in. So I've been doing this for 30 years, actually 29 years. Been a lawyer for 30 years, but the first year I was a lawyer, I was getting a second law degree, a master's in tax law, Boston University Law School. And then 29 years ago, I started actually working as a lawyer and really jumped into estate planning from day one. And so historically, probate, which is this court supervised process of validating someone's will and overseeing the administration of accounts and real estate and court supervision over the distribution of the assets pursuant to the will under all of the procedural rules. I think historically, you had to go through the courts to settle somebody's estate because historically, the purpose of probate, or one of the main purposes of probate, was to make sure that the deceased person's bills got paid, their creditors got paid. And so when somebody died, you couldn't transfer things to the heirs until you gave the proper notice to the creditors, until you let certain time periods lapse within which creditors could come collect their debts from the estate. And I think those reasons probably don't exist as much today, because if people have debt, and many people do when they die, oftentimes it's home mortgage debt, and that lender's going to have a mortgage on the property, so they're going to get paid when that property gets sold. People have car loans, and those lenders are going to be protected by the lien that they have over the vehicle, so the vehicle can't be sold or transferred without the bank getting paid off. And so, yes, we do have people who die with unsecured credit card debt, and that's a whole area in itself. We really don't see too many credit card companies getting involved in someone's probate. Somebody dies, they have $5,000 of credit card debt. I don't want to speak for the credit card companies, but it seems like in many of those circumstances, they just they take what they can get. If the family will voluntarily pay that bill that the deceased person had, they'll pay it. And quite frankly, I think credit card companies just write it off, let it go, whatever you want to call it. So I think this historical purpose for probate of making sure that someone's debts get paid before their assets go to the heirs, I don't think that reason is quite as valid today as it was maybe 40, 50 years ago, before so much was done electronically with liens and all of that. It's just gotten a lot easier for lenders to secure their debt. Okay, but nonetheless, I want to start with an example, start with a story. Do that just on most of these videos. It just makes it easier for people to understand. I'm going to talk about maybe a mother who died, maybe one mother who died, and her heirs went through the probate process, and then another mother who died with very similar circumstances, but her estate was arranged to avoid the probate process. What did that look like? What were the pros and cons? Okay, so let me just set out the facts. Let's call it mom number one and mom number two. Mom number one, well, both mom and number one and mom number two had similar assets. And these are assets that many people have when they pass away. They each had a home. The only maybe unusual thing I'll apply here is, let's say each of them had a piece of real estate out of state. Maybe it was family property, maybe it was vacation property, maybe it was rental property, but they owned a piece of property out of state. And then they had the typical things. Mom number one and mom number two each had an IRA, individual retirement account. Mom number one and mom number two each had a brokerage account, because many people who have accounts at the Merrill Lynch, Edward Jones, UBS, TD Ameritrade, all those large brokerage firms, they often have multiple accounts at those financial institutions. They'll often have their IRA, but they'll often have a separate brokerage account, and that becomes real important when we talk about probate here in a minute. So mom one and mom two each had an IRA and a brokerage account. And then mom one and mom two each had one or more bank accounts, because just, everybody has a checking account. Some people have savings accounts. Some people have CDs. And then they each had a vehicle. So that's kind of the normal stuff that people have when they pass away. Now we'll talk about mom number one. Mom number one, I'll give you two examples of mom number one. One is she had no will. And another example is she had a will. She named her daughter Linda as the executor, and she left her estate to her three children equally in her will. And here, both mom number one and mom number two have 3 children, and they both want their estates to be divided among the 3 children equally. Okay, so mom number one dies. Let's say she has a will. She appoints daughter Linda as the executor, and she leaves her estate to her 3 children equally. And she has a home, she has other property, she has an IRA, a brokerage account, bank accounts, and a vehicle. Okay, so what happens after mom number one with the will and with all of these assets titled in the name of mom number one? What happens? Well, some assets are going to be frozen, and some assets will be dispersed to the 3 children a little easier. So let's say the 3 children get together after mom dies. They're cooperative, they're friendly, and I will tell you, if they're uncooperative and unfriendly and they want to bicker, all bets are off. Things are going to last for years. We're talking about situations here where the heirs are amicable, they get along, they love each other, but nonetheless, they want to each make sure that they get what they're supposed to get, and that there's no shenanigans going on. All right, so the 3 children get together after mom number one dies. They all take a look at the will. The will names Linda as the executor. The will says, I leave my entire estate to my 3 children equally. And the 3 children say, what are we going to do? And maybe after a little bit of a conversation, they say, well, you know what, let's go ahead and sell the home. Let's sell the out-of-state property. Let's go ahead and get the IRA transferred to the 3 children. Mom has 300 shares of ABC stock in her brokerage account. Let's just make sure each of the 3 children get 100 of those 300 shares. Let's divide up mom's bank account, and let's also, let's give the granddaughter the vehicle. Mom always said she wanted granddaughter to have the vehicle after mom died, so let's do that. So that's what they all agree on. And then at the end of the meeting, they're like, what do we do next? Because they go to the brokerage account, and the broker says, the brokerage firm, and the financial advisor there says, your mother's account, we're required to freeze it. You need to go get a lawyer and go through probate. And then they go to the bank where mom's bank accounts are. And the banker tells either Linda or the 3 children, your mother's bank accounts are frozen. You need letters testamentary. You need a judgment of possession. You need court orders. You need this. You need that. You better talk to a lawyer. And so the next appointment that they make is an appointment with a lawyer. Maybe could have been me, could have been somebody else. And so the 3 of them go see the lawyer, and by the time they go see the lawyer, the 3 kids probably got together maybe a week after mom died. They probably started bouncing around mom's financial institutions for another week, and then they realize we need to go get a lawyer. So maybe they schedule, and maybe a week later they're now meeting with the lawyer, and so they're meeting with the lawyer maybe 3 or 4 weeks after mom died. Lawyer says, well, in this set of circumstances, your mother had a will. She named you as the executor, Linda. I think we need to get all the court pleadings prepared to get the will probated. We talked about that earlier. Get the judge to declare that it's a valid will, and get a judge to sign the appropriate court orders that Linda is confirmed as the executor. So the lawyer says, come back in 10 days and I'll have all that paperwork ready. The 3 of you can sign the paperwork that you need to sign so that we can go file it at the courthouse to get Linda confirmed as the executor. So they come back 10 days later, they sign all the paperwork. A week later, the lawyer goes to the courthouse and opens the probate, or opens what in Louisiana, what we call the succession, files all that paperwork. And then it goes through a processing procedure where that paperwork makes its way to a judge's office, and a judge likely has some young lawyer / law clerk there to review all of the court pleadings. And to the best of that law clerk's knowledge, all of the pleadings are done correct. The will appears valid. The judge signs the order probating the will, and the judge signs an order confirming that Linda is the executor. And that's up on the 12th floor at the courthouse. So that paperwork makes its way back to the basement, where the processing department will sign, stamp, make multiple certified copies to get all of those back to the lawyer. And then the lawyer gets that to Linda, and Linda's off to the financial institution. So what she'll do is she'll go to Mom's banks where Mom's bank accounts were frozen. Linda will open up an estate account at the bank, and with the appropriate court orders, after the bank's lawyers review them, the bank will move the money from Mom's frozen account into the new estate account that Linda has set up. So that account is titled Estate of Mom Number 1, Linda as executor. And then she does that at the bank, and she does it at the brokerage firm where she establishes an estate account at the brokerage firm, and then the brokerage firm moves Mom's investments that are in Mom's frozen brokerage account from the brokerage account into the estate account. And now that Linda has been confirmed as the executor, they get with a realtor, or maybe they'll sell those properties for sale by owner, but they'll kind of formally put those, the home and the out-of-state property, for sale. And you know what, let's say, for example, the family decides to keep the out-of-state property. It's a condo on the Florida Gulf Coast. Kids want to keep it. They want to use it. They're going to keep it. So Linda puts the house up for sale, and who knows when she'll find a buyer. But let's say 5 months later, she finds a buyer. The estate, Linda as the executor of the estate, sells the house. She sells it for $300,000 or whatever she sells it for. Those funds at the closing are payable to Estate of Mom Number 1 with Linda as executor. Linda deposit those funds into the estate account. And the vehicle still sits there because they want to give it to the granddaughter. So now the bank account money is in an estate account at the bank. The brokerage account investments are in an estate brokerage account at the financial institution. The house has been sold. That out-of-state property still sits there in Mom's name, and the vehicle is in Mom's name. And so now we've got to prepare more court pleadings. They come back to me because we got to go back to court with all the inventories of the assets and follow all of these kind of archaic probate rules where we have to do accountings and we have to inventory assets and debts and all that stuff. And then a judge will sign a final court order ordering that the remaining estate assets be distributed to the 3 children. So then Linda will start the process of closing the estate accounts, maybe retaining funds to pay Mom's income tax next year and income tax preparation, but the bulk of the funds will be dispersed out of the estate account to the 3 children. Now, the vehicle was listed on the inventory of assets because they didn't sell that. So the final court order will order that the vehicle be transferred to the 3 children. And, oh, by the way, Mom had an IRA, but she named the 3 children as the beneficiaries. So the 3 kids didn't need any lawyers or court orders to get that IRA money. They just needed a death certificate, take that to the financial institution, and then the financial institution would set up 3 new inherited IRA accounts, divide up Mom's IRA into the three new inherited account IRAs. No probate, no court orders required to transfer an IRA or life insurance or an annuity at death, because those are kind of items that can be transferred pursuant to a beneficiary designation form with the financial institution. All right, so that's a key point there. All right, but now you're starting to get an idea. The kids will take that final, what we call here, judgment of possession or final court order to the Office of Motor Vehicles, and then the Office of Motor Vehicles will issue a new title in the 3 children's names. Now the 3 children can donate their interest in that vehicle to the granddaughter, who the 3 children want to have the vehicle. So that takes place. And now the estate is kind of wrapped up. The brokerage firm will also establish new brokerage accounts for each of the 3 children. And once the final court orders are signed, then the brokerage firm will transfer the 300 shares of ABC Inc. stock from Mom's estate account, Mom Number 1's estate account, 100 shares to each of the new 3 individual brokerage accounts on behalf of each of the 3 children. So, all of that stuff, it takes some time and it takes some money. You're hiring lawyers. Probably the biggest expense is, there's lawyer charges, there's court filing fees. Sometimes there's accountings that are necessary. And so all of that takes time and money, but the family gets it and it gets done, and they kind of go on their merry way. And that whole procedure, it could have, if it was very efficiently done, meaning kind of the day after mom died, the 3 kids are in the lawyer's office and everybody was boom, 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 kind of ready, willing, and able to get stuff done immediately. There were no lapses. Things went fast at the courthouse. Paperwork didn't sit on a judge's desk for weeks or months at a time. Maybe in a kind of a quick scenario or a normal scenario where there's no complications, it might have taken kind of maybe 3 or 4 months to get all of that done. But the chance for there being some complication, because there are so many moving parts, from the lawyers to the parties, to the children, to the courthouse employees, to the judge's office, to the people that you have to work with at the financial institutions and their lawyers who have to interpret court orders. With so many moving parts, there can and often is delays that really aren't the fault of anybody. It's more of the fault of kind of the system. And what I think causes some stress is that on that day that mom number 1 died, and the 3 kids discovered that, mom's estate was worth $900,000, $600,000, $3 million, doesn't really matter. But those kids, on the day that they met shortly after mom died, they kind of felt like that's their money. And they started behaving and acting like they already had it. And so they started kind of looking around at the new cars. They started looking around at the new homes. They started, going shopping. And because they were expecting that windfall, and they knew that $900,000 was just sitting there, and they were just a step away from getting the $300,000 because there were 3 children. So they started acting like they had it. And then delay comes, and then another delay comes, and then another delay comes. And that creates some stress. And then, what I saw recently was, the market collapsed. And so what was $900,000 turned into $700,000. And that caused more stress. Why can't we get this done? Why isn't it over? The investments are just going down, down, down in value. So, sometimes you see some stress in that proceeding. And so that's just, it's just the nature of these events. So that's kind of a common scenario when there is a probate. I wanted to kind of teach you what a probate was by giving you an example. But the title of this presentation is more about, what's the fuss about probate and should you avoid probate? So now I want to tell you an example about mom number 2, who did want her 3 children to avoid having to go through that court and attorney involved probate process, or as we call it in Louisiana, some people call it a succession when somebody dies. So mom number 2 had the same family circumstances as mom number 1. She had 3 children. She wanted everything to go to her 3 children equally. She had a home. She had out-of-state property. She had an IRA, a brokerage account, bank accounts, and a vehicle. Oh, by the way, since the kids wanted to keep the Florida condo after mom died, and they wanted it put in their 3 names as co-owners, after they finished the in-state probate, which does not address out-of-state property, the kids had to go hire a Florida lawyer or law firm to take them through what's called the Florida ancillary probate to get that Florida condo transferred into the 3 children's names. So it wasn't enough that they had one great lawyer in their hometown, in their home state, to take them through a probate. They had to go do it again in another state to handle the transfer of the out-of-state property. Okay, so that's a good question. By the way, another Alex, hello to Ohio. Thanks for the great information comment. John M. Again, I love the live chat comments. Is the income that is made on the estate during probate taxed at 37% like a trust? Short answer is yes. Long answer is well, it depends on how much income the estate has. Because let's say a person dies on December 31st. Not many people die on December 31st, but this is an example. And then the estate takes a year to get settled. So the kids wind up with the investments, with the assets, with the rental property, with the stock. The kids wind up with those assets in their name on the following December 31st. So there was a year where the assets of the deceased were owned by the deceased's estate. And so now and those assets produced income. They produced dividends. They produced interest. They may have produced some rental income. And so that's income of the estate. And yes, before the deceased person died, all of that income was reported on the income tax return of the deceased person, the 1040, just like everybody does. And then once the heirs received the assets, and then as those assets produced income, the heirs reported that income on their return. But during that year, while the estate had income, the estate must file an income tax return and pay estate's income tax. And as I described on yesterday's YouTube live presentation, a married couple filing jointly doesn't pay tax at 37% unless they have, I think it's $622,000 or more than $622,000 of taxable income. But an estate pays income tax at that highest 37% rate when an estate has income exceeding $12,950. So not all of the estate's income gets taxed at 37%, but all of the income in excess of $12,950 gets taxed at 37%. So you hit that 37% rate pretty quick. Now, I will admit most estates don't have a whole lot of income unless they're a large estate. So, if mom had $1 million CD or brokerage account, and let's say during the year that the estate was being administered, it produced, I'm not talking about appreciation, but it produced those assets produced 1% income, whether that was interest or dividends, or let's say 2%. That would have been, $20,000 of income that the estate would have had to have reported and paid income tax on. So some of that $20,000 of income would have been taxed at 37%. All right. I'm going to get to you here, and Dean Preston Sr. in a minute. Coming at you. So there's your answer. Hope that helped. All right. And getting to Dean Preston Sr., do non-titled items such as jewelry or firearms trigger probate? Short answer, no. Long answer, maybe. So here's the deal. Let's say, as we're about to discuss mom number 2, who set up her estate to avoid probate, let's say that home and those brokerage accounts, none of that required a probate when she died. All she had was some jewelry, she had some non-titled personal effects. She had a whole slew of furniture, she had some art, she had some nice jewelry, and the 3 kids were to get that equally. Really, that stuff is not required to go through any kind of formal probate proceeding because it's not titled. The reason heirs have to go through probate is because there's an asset titled in the name of the deceased person, and you got to get a judge to order that the title of that asset be transferred to the 3 heirs, like a home, like investments, like financial accounts. So those assets are frozen, and you got to get a judge to unfreeze them by ordering that they be transferred to the heirs. Non-titled personal effects, well, unless there's some reason out there to put those through the probate process, typically the heirs just take physical possession of those items and then they go their own merry way. Now, I would say if mom had a will leaving all of her personal effects to her 3 children, and the day after mom dies, one child goes in, cleans out the house, goes and puts everything in their own storage, really keeps the other 2 children from, trying to figure out how to properly divide those things, then yeah, you're probably going to see the parties lawyer up and go through the probate process to force that one who went in and took everything to give it back and do what they need to do. But I'd say in general, no, that probate isn't required to deal with those non-titled firearms, jewelry, things like that. All right. You're welcome, John M. All right. I have another good friend named John M. I got a Tippy and a John M. So real good stuff. Okay, so now we're going to talk about the example where mom number 2, she wanted to arrange her estate so that her kids wouldn't have to go through probate. Had the same stuff: home, out-of-state property, IRA, brokerage accounts, bank accounts, vehicles. Mom number 2 goes to a lawyer while she's alive and while she's healthy and says, I want what I have to go to my 3 children. I want my daughter Linda to be in charge of making sure that each of my 3 children inherit what I have equally. And I'd like to avoid probate. Maybe mom number 2 went through a probate when her father died years ago, and it was a hassle. And so mom number 2, so the lawyer tells mom number 2, well, if you want to avoid probate, instead of leaving everything to your children through your will, perhaps we should set up your mom number 2 revocable living trust and title those assets that are presently in your name, retitle them into your trust. Things that are in a trust when you die, the courts don't want to have anything to do with overseeing the disposition of that. They only want to be involved when assets are in your name when you die. And so what we'll do is we'll set up your mom number 2 revocable living trust. We'll have that trust say that you're the trustee and you can do whatever you want to with those trust assets while you're alive. You can buy, sell, spend, give away, do whatever you want to do. But your trust will say when you die, your daughter Linda, her title will be the successor trustee. And the trust will say that it's her job to do what she needs to do, sell what needs to be sold, but make sure everything gets divided up 3 ways equally among your 3 children, one of which is Linda. Okay, so Tippy, again, good question. I'm not sure how attorney networking works, but if you know any estate planning lawyers in Maryland that you don't mind recommending, please do. Can't think of any offhand, but if it comes to me, you'll be the first to know. I do know a lot of lawyers around the country, so if you have a request, feel free. Okay, so mom number 2 says, I like the sound of that. Let's set up my revocable living trust because I want my kids to avoid having to go through courts and lawyers when I die. So the lawyer and mom number 2, they establish the mom number 2 revocable living trust. The lawyer does the paperwork to transfer not only mom's home, but the out-of-state Florida condo into the trust. Now those properties are titled mom number 2 as trustee of the mom number 2 revocable living trust. Mom goes to her brokerage firm or her financial institution and she retitles her financial accounts from the name of mom number 2 to mom number 2 as trustee of the mom number 2 trust. So she can still do whatever she wants to. There are no restrictions at all put on mom number 2. Mom uses her own social security number as the tax identification number for the trust because this is what's called a grantor trust. trust, which means the trust is really invisible for income tax purposes. The trust doesn't file a return. Now, it's different, as you mentioned earlier in the live chat, when mom died and the estate did have to get a tax ID number and report income. But on mom's revocable living trust, it's really all the income just flows through to mom, and mom just includes all of that on her personal return like she's always done. And so now mom holds and has assets titled mom number 2 as trustee of the mom number 2 revocable living trust. What that did was when mom number 2 died, those trust assets weren't frozen. And Linda, mom number 2's daughter, as the successor trustee of mom's living trust, has immediate access to do what Linda needs to do with those assets. So the day after mom dies, Linda could sell mom's home. She's the trustee. There's no delay. Don't have to get judges involved. She can sell it the next day. She can, after mom number 2 dies. The day after mom number 2 dies, that property can be transferred out of the mom number 2 trust, that Florida property, to the 3 children. So Linda may have to get someone in Florida to do that deed transfer, where Linda would sign transferring it out of the mom number 2 trust, and the 3 children would sign accepting it as co-owners of that property. That would get recorded in the Florida county records. That's what would make the 3 children the owners of that Florida property. The day after mom died, or maybe at the latest when Linda got mom's death certificate, Linda could go to mom's financial institutions, set up 3 new accounts, 1 for each of the 3 children, and direct the financial institutions to move mom's funds, mom's stock, from mom's trust into the 3 children's accounts, 1/3 each. So literally in a matter of what could have been days, and probably was days as opposed to months or years, mom number 2's estate got settled. Linda and the children, they didn't need to get lawyers involved, which is the main expense when probate is necessary. Courts, obviously, and judges were not involved in any of these transfers. So the idea was mom number 2 set things up. She created her trust and transferred title of assets to her trust, so that immediately when mom number 2 died, Linda, as the successor trustee, could access those assets and divide them up equally among the beneficiaries. The IRA, by the way, stayed in the name of mom number 2 because the IRA avoids probate anyway. It has designated beneficiaries. And so as soon as the family got the death certificates, the 3 children would work with the financial institution, and they'd move the money from mom's IRA into the 3 new inherited IRA accounts, 1 for each of the 3 children. Same thing would have happened with life insurance and annuities. Once the death certificate comes in, the 3 kids can just go work with the financial institution directly, and then they'll divide up the money. Okay, so that should give you an idea of this, what happens when you go the kind of traditional, customary route. It's what you see in the movies. People get their will done. It's what you hear about when, oh man, I don't even have a will. So a lot of talk about will. But in reality, I think most families and most parents and grandparents and those who are going to be, leaving a legacy, an inheritance, a collection of assets to their survivors, they like the concept of being able to arrange it so it's outside of all of the court involvement. So I'm going to get into some of those pros and cons here in a minute. In fact, in many states, there's just no debate at all about what people should do. I have colleagues, lawyer friends, lawyer colleagues in states like California and in Florida, and it seemed that I've really, I don't know that I've ever seen any of those lawyers or heard any of those lawyers say, you know what, it's really easier for families when someone has a will and they just let the probate process govern and oversee the whole settling of the estate. That doesn't happen in many of those states, because in many of those states, the probate is a nightmare for a number of different reasons. Even when every participant is 100% supportive of one another, you have these required several month-long delays still as part of that state's probate procedure, where heirs just have to wait. And then you have all of these statutory percentage of the estate fees that go to executors, or that go to lawyers, or that go to the courts. And so, when someone has $1 million estate and you add up these required percentage of the estate fees that must go to others, and it turns out to be 7-8% of the estate on $1 million estate, that's $70,000 or $80,000 of expense that could have been avoided if the person who died had arranged their estate to avoid that probate process. Okay, so again, another question, great question, Paul. Is it better to put the IRA in the trust or designate beneficiaries through the IRA? All right, you know what? You're really going to want to listen to tomorrow's YouTube live presentation, but I'm going to answer your question. So let's say mom owned an IRA while she was alive. Well, while she was alive, mom can't transfer her IRA to a trust. An IRA must be owned by an individual. So now, there's no real need, even if she could transfer it to a trust, there's no need to, because mom can name beneficiaries of her IRA, and when mom dies, those funds get paid directly to the beneficiaries without courts and lawyers being involved. Where we hear trusts with IRAs, we typically hear the question about whether mom should name a trust as a beneficiary, or whether she should name her living trust as a beneficiary of her IRA when she dies. Lots of discussion on that tomorrow. In fact, last night, you could go find it on YouTube. There's a video I made about this, I don't want to get real over everybody's head, but this conduit versus accumulation trust as a IRA beneficiary. May want to take a look at that. It's about 20 minutes long. But that starts to get into the naming of a trust as a beneficiary. Now, good question from Alex. Does that apply to annuities? Yeah, annuities, just like IRAs, have beneficiaries. And so if the goal here is to avoid probate, there really is no need, while it is possible to transfer ownership of an annuity to a trust, it's often just not necessary, because you name beneficiaries, and just by naming beneficiaries, you're avoiding probate anyway. Now, if someone has an IRA or an annuity and they name their estate as the beneficiary, then it runs through the probate stuff. And so really, there's very few circumstances where someone should name their estate as the beneficiary of their IRA, their annuity, or perhaps even their life insurance. Okay. So in many states, no debate. Kind of the common knowledge, if you got anything that would require a probate process when you die, get yourself a living trust and avoid the probate process, because the probate takes a very long time and it's very expensive and it's just a flat out hassle. And so, but here I'm in Louisiana, and there seems to be a debate about whether people should use wills to leave their estate to their heirs or use a living trust. And let me kind of give you some of the history of why I think there's a debate, because some people say once they get educated, or once they've been through either a probate where it was difficult, or they've been through a trust that got settled very quickly and easily, and neither one of those are always the case. There are some probates that are simple, and there are some trust settlements that are difficult. So, and that all has to do with who's involved, how organized things are, what are the relationships of all of the parties involved, who's the lawyer handling things, if a lawyer is involved. So all that plays into it. But in Louisiana, there seems to be a difference of opinion. a lot of people, when they look at this, they kind of say, well, wouldn't everybody want to arrange their estate to eliminate the need for that probate? And my first reaction is, don't get stuck on this paralysis by analysis. Just make a decision and go with it. But some people say, trusts really aren't necessary here in our state. Some people say everybody should have a living trust. So here's the background on that. So when I started working as an estate planning lawyer 29 years ago plus, it seemed like, I worked for the firm, I worked for the big firm, and it seemed like virtually all estate planning lawyers around me were writing wills. Some clients would question or ask, hey, what about this living trust thing? Should I have one of those? I hear that avoids the probate or avoids what we call in Louisiana the succession. And the lawyers would kind of just for some reason kind of quickly talk their clients out of it. They'd say things, probate's not so bad, blah, 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 blah. And so the reason lawyers would do that, in my opinion, were several. I know in law school, I went to Louisiana State University, and I have two kids who have already finished law school at Louisiana State University. I have another son who's at Tulane Law School, and all of the teachings, now estate planning is not a large part of the curriculum in law school. There's usually one class, and I don't know what it's called, something like wills and successions and donations, probate. So my point here is from an estate planning perspective, at law school, it's all about wills and probate. And so that's what's taught, or wills and successions. Very little, if anything, is taught on using, living trusts as a vehicle to dispose of your assets when you pass away. So lawyers come out of law school thinking kind of there's one way to do it. It's wills and probate. And so 29 years ago, when I started working as a lawyer, that's what everybody did. I kind of heard of these living trust things, but none of my superiors were talking about it much. And when a client asked about it, they just kind of blew them off. And lawyers were, in my view, kind of comfortable advocating or recommending, that couples, because oftentimes estate planning is done by a married couple, husband and wife. Lawyers, I think, were very comfortable with the wills and probate scenario. They got paid 3 times at least. They got paid when they set up the wills and powers of attorney and all the other ancillary stuff that went with it. And then when the first spouse died, the family would go back to the lawyer because the family was stuck. Accounts and real estate titles were frozen, so they had to go back to the lawyer to do the probate when the first spouse died. And then maybe a few years later, when the surviving spouse died, the family had to go back to the lawyer or law firm to gain access to the family assets because, again, they were frozen when the surviving spouse died. So the lawyer got paid 3 times, and lawyers got kind of comfortable doing that. In addition, there were, and I'm going to use the word sleazy, there were sleazy insurance and annuity salesmen who have been out there for the last 3 decades, really advocating, don't do a will, don't do a trust. I mean, they were saying, don't do a will as the vehicle to leave what you have to your heirs. Do a living trust. Now, they weren't advocating that, the sleazy insurance salesman and annuity salesman, they weren't advocating living trusts because they were looking after the best interests of their prospective clients. They were advocating living trusts to their prospective insurance and annuity buyers because if the insurance salesman was going to help them set that up, that prospective client needed to disclose to the insurance salesman all of the financial accounts that that person owned, which would make it easier for the insurance salesman to make their insurance or annuity sale. Because part of getting a living trust set up is disclosing what you own so that those accounts can be retitled into the name of the trust. And so with the sleazy, and I don't use the word sleazy to indicate that all people in the insurance and annuity and financial services field are sleazy. God only knows there's enough sleazy attorneys out there, but there were people in the financial services field who were going through the back door by helping people set up living trusts so that those sleazy salesmen could find out exactly how much money those people had so that they could sell more insurance and annuity products. And I think the kind of blue blood lawyers who were advocating wills and probate, they didn't want to be giving the same advice as the sleazy financial people were. And so the lawyers kind of stuck with their will and probate advice, even though the financial people were advocating trusts, which some consumers wanted, but the insurance salesmen were advocating it for the wrong reason. So that created some conflict for there. And for that reason, I think many lawyers just kind of stuck with their guns and advised their clients to do wills and the probate or multiple probates, depending upon whether it's a married couple, and multiple probates, depending upon whether a person owned real estate in more than one state. So it's a complicated thing. In addition, I think a lot of lawyers kind of pass it along as, probate is not that bad. But when I talk to lawyers, I hear one thing. When I talk to consumers, it's like I hear a different story. And what I find is that the consumers out there tend to be the type who, those parents, those grandparents, they look at this as their kind of last opportunity to do something for their family. And they not only like the idea of keeping their family out of the court system, they just like the idea of doing whatever they can do to make it easier for their survivors. And if that means they got to do a little more now to make it easier for their survivors in the future, the people that they love the most, then they like the concept of this living trust arrangement because they want to do what they can to make things easier for their survivors. Now, I will tell you, over the last 3 months with the COVID-19 coronavirus, whatever you want to call it, that virus that we had did no justice for probate because courthouses flat out shut down. And so we were dealing with some probate scenarios where people couldn't get the money. They a mother or father died, accounts were frozen, courthouses were closed. There's only so much us lawyers could do, and no one could get at the money until courthouses have started to open back up. Judges have started to come back to work. Court orders ultimately are now starting to be signed, and it's causing additional delay in the families gaining access to assets under the probate proceeding. So that's been a kind of knock on probate lately. All right. So really there you have it. You've probably never heard it that way, but I wanted to spend another 54 minutes, the history behind probate, giving you two examples of identical people, one family arranging in a manner that required the probate, one that avoided the probate, let you make the decisions, give you some of the underlying backstory on wills versus trusts and how some lawyers feel about it. Tomorrow is a biggie. Before I tell you about tomorrow's YouTube live presentation, I am going to encourage you to smash the like button. It's one of only about 3 things I sell on these YouTube live presentations. I like giving about 99% good, solid information that you can use and take to your people or whoever. But I do want to sell you on smashing the like button, on hitting the subscribe. None of this costs anything. Hitting the subscribe button and the notification bell so that when you pull up the YouTube website and they give you some suggestions of videos to watch, if you've subscribed, they'll likely show you one or two of my videos. It just gets YouTube to it tells YouTube to send my videos and show my videos to more people. I'm just trying to spread the word. I'm trying to get up to, I kind of have this little goal of trying to get up to 10,000 subscribers on my YouTube channel. I think I'm around 6,200 right now. But if you could share this information with others tomorrow, if you know somebody who owns an IRA, you're going to want to get them on tomorrow's YouTube live presentation. Significant changes to our rules and regulations on what you can do kind of from the grave to control your IRA money after you die. I'm going to go through all of that. I've done a lot of, believe it or not, self-study on this issue just in the last few months because the new Secure Act took effect for people who die on or after January 1st of 2020. So we got a whole new set of rules. And it's really interesting as to see what you can do with your IRA, which is for many people by far the largest financial asset that they have. So the IRA beneficiary designation should not be just an afterthought. There should be, some proactive, informed decisions made about that. That's what tomorrow's YouTube live presentation is about. So if everybody who watches this, and probably today about 200 people will watch this, only it looks like 23 or so present right now, but then a lot of people are going to watch the recording afterwards. So if you know somebody who has an IRA, particularly large IRA, tell them, hey, I got this lawyer. He's going to tell you all about IRA beneficiary designations tomorrow. I don't want to throw out these over your head terms of conduit trust, accumulation trust, trust as beneficiaries, but you're going to be an expert after you watch the YouTube live presentation tomorrow, 10 a.m. Central Time. Share it with everybody you know. Like the video, subscribe, all the good stuff. If you got a joke, bring it on tomorrow because we're about to finish up here. Let's see. I think we got all the questions answered today. We got the last one from Lawrence about putting the IRA and you can't. Oh, wait, is it wise to put IRA and brokerage account? So that's a good question. Can't put your IRA in a trust. You could name it as a beneficiary, more on that tomorrow. But by all means, yes, you should put your brokerage account into a trust. Many states, those accounts just get frozen when you die because you don't have beneficiaries like you do with IRA. So the brokerage account, yes. So oftentimes people have an IRA and a brokerage account. Their brokerage account goes in their trust. Their IRA stays in their name. Thanks for the great info. Question on the house, which is jointly owned with spouse, so no probate, but would you still recommend a quitclaim deed? Yeah, it depends on your state and where you are, but the problem could surface after both spouses die. It's got to go through probate. So if you put it in your trust with a quitclaim deed, it won't go through probate. Your successor trustee of your trust will be able to do what they need to do with it after both spouses pass away. That's a quick answer. I hope it's applicable based on where you are and what your circumstances are. I'm Paul Rabelais. I'm going to estate planning my last sales piece. For those of you particularly who have a Louisiana interest, you can go to the description. You can go to my website. Not many people coming into the office these days, but a lot of people are requesting a 15-minute free call by going to the website, clicking on the button. You'll see my calendar. You schedule the 15-minute call. I'll call you promptly at the predetermined time. Jot down your issue in the comments. We'll see you tomorrow. Y'all have a great day. About the same number. I never had more than about 25 or 30 at one point. A lot of questions and a lot of good chat. Oh, I think y'all hear me. I think I was